We oftentimes showcase questionable police encounters. And while there may not be much of a remedy for a hot-headed officer, if you encounter a competent officer who respects the Constitution, we have some tips that you need to follow. And with more on this, we have Eddie Craig of Rule of Law Radio. All right, thank you for joining us today, Eddie.
Thanks for having me on.
Okay, so we hear a lot about people filming the police. You know, they encounter the police, whether it be a traffic stop or someplace else. We talked about just earlier in the show about the unfortunate incident in South Carolina, and somebody just happened to be filming the officer as he shot a man in the back, pretty much killed the guy. So can you explain to us the importance of the civilian or just the normal person being able to film a police officer in the commission of their duties?
Well, it's extremely important. Right now, there is almost no level of public accountability for law enforcement and various other government entities for that matter. Without the power of the video and the audio recordings, there would be a lot of people in jail right now, in prison, being convicted for crimes they never committed because officers have falsified the reports they filed, trumped up charges on people just to cover their own wrongdoing. The camera is the only eye we have into that after the fact. Eyewitness testimony can be discredited. The camera is a whole lot more difficult to discredit.
Right.
So it's extremely important.
So we see this all over the country, but particularly here in Texas, they're trying to pass through a bill. I believe it's 125 feet. You cannot film the officer, which is to say if you were engaged in a traffic stop, I'm the officer, you can't film me because I'm within that 125 feet. Does that set a chilling precedent?
It would if it would actually be able to pass. It very well would. But then again, it would also run directly afoul of current rulings by the U.S. Supreme Court, and it would not be a difficult thing to have that law declared unconstitutional on its face for that particular violation. But at the same time, the problems it would create on the accountability issue we've just discussed would be astronomical.
Right. Now, Eddie, why we have you on here today is to talk about the reasons why police are pulling people over more and more. It's gone beyond speeding, and we'll talk about that as well. But here in Texas, as well as many other places around the country, they're coming up with new reasons just to pull you over. Let's say you have your cell phone out. They just passed that here in the city of Austin. You're driving around, maybe you're looking at your GPS. If you're looking at a map, if you're distracted in any kind of way, they can pull you over and, Mr. Craig, we see that you're driving distracted. Can you explain to us the significance of this precedent?
Well, the first thing is this is both the city of Austin through its ordinance program and the state itself in an upcoming bill attempting to legislate human behavior. And that's simply not feasible. It's not going to work. The only thing that it's really going to provide is a steady revenue stream for both parties, the state and the city, which deep down we would have to consider to be its true intended purpose. None of this would actually impact public safety one way or the other any differently, I don't think. In fact, it would probably make it worse because now if someone gets an unexpected phone call and they're expecting something important or whatever, they're going to try to answer it, but they've also got to now be worried about whether or not there's a cop present that would catch them doing so. Not everybody can afford hands-free devices and things like that in their car. So the issue is that this isn't really about public safety. And for them to put it out there as if it is can easily be disproven if you really think about it. The argument, I believe y'all had an attorney on the show here a few weeks ago that was discussing this particular ordinance. I actually saw part of that show, and I was really wishing I was on set at the time and able to go toe-to-toe with this guy.
Well, tell us the issue you had with it.
Well, the issue I had was the fact that it's ordinance-based to begin with. What most people in the state, and including those that are making them, fail to realize is that ordinances are not binding law on the public. I know that the states and the prosecutors and the city attorneys, they all want you to believe it is, but the problem is the state constitution says they're not. We gave only one legislative body power to create law binding upon the public, and that was the Texas legislature. It was not the municipalities. What the legislature did to empower that concept, which we'll be doing a presentation on here if I'm not mistaken, was actually very, very unconstitutional. They attempted to convey a power that the courts themselves have ruled they can't convey, which is the ability to legislate. And they did that through nothing more than the creation of statutory definitions. And in the presentation, I will show you exactly how they attempted to do that. But the ordinances themselves are not law binding upon the public. They can't be. We didn't authorize municipalities to create law binding upon the people.
All right, and what Eddie's talking about here, we'll discuss in a presentation that is going to premiere next week. He's going to shoot with us right after the show, but let's get back into it, Eddie. We were talking about speeding, and you brought up something very interesting to me, something that I didn't know. He talked to us about speeding limits and how they are set.
Yes, there is a problem with the way they're prosecuting speeding charges here in Texas. The two statutes involving speeding are 545.351 and 352 of the Transportation Code. Most municipalities, the prosecutors attempting to prove only the elements of 545.351 subsection A. The problem with the language of subsection A is that it's vague, ambiguous, overbroad, and highly subjective to the opinion of whoever's making the allegation. The language there more or less simply reads that a person commits an offense if they operate a motor vehicle to speed other than is reasonable and prudent under the circumstances then existing. There is no criteria in A for what the circumstances then existing are that would make it an offense. There is no criteria for what reasonable and prudent is under that statute. Those provisions are detailed in subsection B of 351. And subsection B is where the meat of the speeding charge actually comes in, but they never prove the elements that are in it. But the required elements is that the person failed to exercise due care so that by the excessive speed they were traveling, they were involved with a collision with another person or vehicle lawfully entering or already upon the highway. And Texas only has prima facie speed limits. Prima facie simply means, as I discussed in my other presentation, on its face or at first glance or until proven incorrect is what prima facie really means. So, for example, the prima facie speed limit on most of the roads around Austin, out on 35, for instance, is 60. Mm-hmm. Let's say you're doing 70 and an officer pulls you over. At that time, the officer has witnessed no collision, nothing except you going faster than the posted speed limit. And so they have no way of proving the elements of subsection B because no collision occurred.
So they can't say that you were driving reckless.
They can't say that you were acting unreasonably because there's nothing to base that on except the subjective opinion of the officer. And the officer is not qualified to offer subjective opinion in testimony in court. But that's exactly what they're asking the officer to do. The problem with the way they're doing it on that speed is that if you demonstrated that no collision occurred at the 70 miles per hour, then who was to say that your actions were neither reasonable nor prudent under the circumstances? Because, as the saying goes, no harm, no foul.
Mm-hmm. And no victim, no crime.
Exactly. And the Texas speeding statutes clearly have taken that into consideration. There are a total of 15 separate elements in a speeding charge. If you follow the statute the way it's laid out, there are 15 elements required to be proven. They never prove more than 6 to 9 of those. And the problem is that in any criminal case, they are required as a matter of due process to prove every single element in an accusation. They don't ever do it. In fact, the Texas District and County Attorneys Association publishes a book that says very clearly in that book that in Texas, speeding in and of itself is not an offense. Now, why would they say that? They say that because it's a prima facie speed limit. If you can demonstrate that you caused no harm, okay, and your speed was not in such an excessive degree as to be considered criminally negligent, then speeding can't be charged against an individual just because they're going faster than the posted speed limit, which brings an issue up for the officer who pulls you over. The officer is going to be questioned on the stand. What's the color of the car that you saw me collide with? Well, you didn't hit anybody. Did I hit a pedestrian? Well, no, you didn't hit anybody. There's no one saying you hit anybody. Then, officer, please explain to me. If all you saw was me traveling faster than the posted speed limit under the condition of Texas having prima facie speed limits, what is your articulable probable cause to suspect me of actually committing a crime that gave you the ability to pull me over in the first place? Mm-hmm. They never want to answer that because they can't. There is no answer for it. And most attorneys will say, well, the probable cause was the violation of the prima facie speed limit. Well, unfortunately, that only jives if you're trying to prove subsection A. It doesn't jive if you are also requiring the elements of subsection B.
Right. Now, what you're talking about here is, I guess you're talking about Texas in particular, but this can apply to other states and other.
It would
sections.
apply in every state with a prima facie speed limit, and I don't know of any that aren't prima facie.
Good. Okay, now we'll get more into this in your presentation, but let's have a brief demonstration. Let's say I pull you over. Okay, so I pull over, hey, Mr. Craig, I'm State Trooper Jackson. I saw you were speeding in your vehicle. Can I see your license and your registration? To which you would reply.
Officer, can any of the information that you were requesting from me be used against me in a court of law or to potentially incriminate me in any way?
I'll say yes.
If you even understand the question, you'll say yes. But most of the time, they will attempt to avoid it. But you are correct. If they said yes, then, officer, I invoke my right to remain silent, and I cannot provide you with that information and documentation.
Now, let me stop you right there, because maybe this is my misunderstanding, but if you get contacted by officer, are you legally objected or obligated to provide them with your name, birth date, or address?
Under the failure to ID, if they have actually told you that you are under arrest, then you are required to provide them with name, address, and date of birth. However, there is no requirement that that be done in physical form. Verbal is all that's required. When you are legally detained, you do not have to provide it to them, but you cannot provide them false information under either of those conditions, which again would be another example of why producing a license could count against you. Texas has a statute that makes it a crime if you've moved to a new address and haven't updated that address on your license. Now, let's say that you've recently moved. You haven't changed the address on your license, but you're outside of their so-called 30-day window to make that change. By producing that license and handing it to the officer, you've now given him evidence to charge you with another offense, failure to change the address on the license. But at the same time, without thinking about it, you just recite the old address, and now you've provided false information under the failure to ID statute, and now you're in a lot more trouble. So the simple production of that license gave him the opportunity to maybe charge you with 2 additional criminal acts.
So if I pull you over and I ask for your license, you're saying you don't have to supply that?
If I invoke my right to remain silent, how can you force me through statute to produce something that you have just said you can use against me in a court of law, or that can potentially incriminate me in some way? What Texas has actually done in that regard is criminalize the invocation of a protected right to remain silent. They will charge you with failure to produce a license if you don't produce one. But at the same time, your right to remain silent prevents them from being able to do that, because that license can be used to charge you with something else.
Okay. Now, Eddie, we're running out of time here, so I just want to ask you a question, moving away from the vehicles. Okay, so let's say you're out, you're walking around, you see the police initiating a traffic stop or some type of thing. So you pull out your camera, you walk up and you start to film the police. Are you in any type of violation of any law, ordinance, or anything just to film a police officer?
As of this moment, no. As long as you aren't close enough to actually physically impede or endanger the officer in any way, which the courts have set a limit of approximately 15 feet.
Okay.
Anything within that, you could be considered physically interfering. But you cannot interfere verbally, and you cannot interfere simply by recording unless you've exceeded that safety width that they've set up. So anything beyond that 15 feet is just the officer trying to exert his power unreasonably. He wants to control the scene. He wants to control the suspect. He doesn't want to have to worry about a bystander. All of that is viable in a manner of speaking. But at the same time, the way they're being trained and the way they're being taught, that camera is an accountability they don't want present. If they can get you to move without having to force you to move, that's what they'll do. The case of Antonio Buehler is a perfect example of an officer abusing the authority.
And for people who aren't familiar with Antonio, he was filming, I believe it was a young lady who encountered the police. The officer said he was pretty much too close to the scene, and then he was subsequently...
There were actually 2. It was on New Year's Eve, I believe, and Antonio was taking a friend of his home. They had stopped to put gas in their truck, and the officers had 2 females pulled over in a car. One of them was out for a sobriety test. The other was still in the passenger seat. The lady in the passenger seat was yelling out the window to her friend not to submit to the sobriety test.
Right.
The officers then tried to charge her with interfering, came over and drug her out of the car. And from the pictures that Antonio took, it was very easy to see they were intentionally inflicting joint pain pressure techniques on her to get her to comply with what they were doing. They were assaulting this woman. And because they were armed, it's aggravated assault. And Texas statutes deal specifically with public servants that commit aggravated assault while displaying a deadly weapon. But in all of Texas, up until the officer in San Antonio assaulted that female college student and broke her teeth out on the curb,
I remember that.
no police officer in Texas has ever been charged under the aggravated assault statute.
Wow.
That was the very first one, and that statute's been on the books since 1965. So that should tell you something about how often these officers commit these acts, but never get punished for it.
Yeah, now, Eddie, I'm going to extend this a little bit because I want to ask you a question. When you want to get your footage from the police officer, let's say you were contacted by a police officer, you have dash cam, whatever. I have personally tried, both as just a person and as a journalist, go down to APD to get footage for something. And it's this ring around, I go in, I submit an official request as a journalist requesting footage of X, and then I call up and it's like, well, you can't have this footage because this case is currently under investigation. I go talk to the party involved. They say, no, I settled my case, I paid all my fees, and they still refuse to produce said footage. What is somebody supposed to do?
Technically, that is a crime under the Public Information Act. 552.353 of the Texas Government Code makes that a crime. Public records are under all circumstances to be given to the public. The ones that are considered public information request material are the ones that are not specifically public record. Some of these you're discussing fall into that category. However, it's a typical ploy for delay and denial by both police agencies and prosecutors to misrepresent what they're doing. The statute very clearly says that in order for them to deny it in the case of an ongoing investigation, the production would have to directly interfere with their ability to either complete that investigation or to pursue that prosecution. If it would not interfere with it, they're not covered by that statute for non-production. Yet the only thing they're doing is filing with the Attorney General's office saying, hey, we have an ongoing investigation, and the AG just rubber stamp it saying, okay, then you don't have to produce
that's pretty much what happened.
Yeah, and the problem is that's criminal. Under that act, that is a crime, both by the AG's office and by that agency. But they do it all the time. So the way we do it here, if we want to do it correctly and make sure that we do it, is if you have a case, make sure you file a motion for discovery in addition to your public information request. And then if they fail to produce, you can file a motion to compel with the court demanding that they produce it for the purpose of discovery. The other thing the Act does not deal with specifically is when you are the defendant in the case and you are acting as your own counsel. In that case, you are every bit as entitled to that information as your defense attorney would be. And for them to withhold that is to withhold evidence in your case that you need to put on a defense with. That in and of itself is a crime. I actually read a letter that was sent to someone by a prosecuting attorney in Texas, and I could not believe what I was reading. This prosecutor was actually telling this gentleman that by choosing to represent himself, he had waived all of his rights to seek discovery, to get depositions, to get public information relating to his case, to seek records relating to his case. In other words, because you don't have one of our bar attorneys, then we can throw you under the bus and there's nothing you can do about it.
Wow.
That is the mindset of these so-called public officials. It's truly what they're teaching the officers is it is really an us against them thing. The problem is they've got the roles completely backwards. We're not the problem. They are the problem because they now consider themselves to be above the people and above the law that belongs to the people. It's unacceptable in my book.
Always interesting. Eddie Craig, Rule of Law Radio. Eddie, tell us your final thoughts and also how can people keep up with your work?
Well, we do our show on Monday night here in Austin from 8 to 10 p.m. My show is Monday nights, the Rule of Law Radio. We don't call it the traffic show anymore. It's just the Monday night Rule of Law Radio show. I also teach a due process seminar class every Sunday down at Brave New Books from 2 to 5 p.m. in which we openly invite, free of charge, any attorney and any law enforcement officer to attend that class. I will never charge an attorney or a law enforcement officer to come to that class. The whole reason for it is I would love for them to have the desire to know if they're doing right and wrong and to come in and see, because this is not my opinion that I give. Everything that I teach folks, I can show you in black and white where it's written into the statute, where it's written into the case law, and I can show you everything. I don't make this up. I work very hard to make sure it's true and accurate.
All right, thank you, Eddie. Always informative, and this is the type of stuff you get if you go to prisonplanet.tv. This is what funds our operation. It allows us to have guests on like Eddie so he can bring you these educational materials. All right, and be sure to tune in next week. We'll have that full presentation from Eddie that he's about to shoot for us right after this. I'm Jakari Jackson from the InfoWars.com studio. Be sure to go to prisonplanet.tv, get yourself a free trial where you can see the Alex Jones Show, the nightly news, the special reports, the rants, all right there at prisonplanet.tv. Jakari Jackson from the InfoWars Command Center, and we'll see you again tomorrow night.
My name is Alex Jones. Most of you know me from my syndicated radio program and my documentary films, as well as InfoWars Nightly News. When I got on air 20 years ago, I had discovered the globalist program, their plan to take over the world, and my focus went from running 6 miles every other day, swimming 2-3 miles a couple times a week, and lifting weights, to focusing on fighting the globalist. I've gone from 279 pounds all the way down to 235 pounds, and the weight's going off even faster. Super Male Vitality, Survival Shield X2 Nascent Iodine, and Oxy Powder. Those 3 products of the entire family of InfoWarsLife.com products are the most important from my own personal experience. And it wasn't just that my weight loss accelerated. My muscle mass increased. My stamina, my energy levels exploded. Now is the time to take action. Start your journey today with the Alex Challenge Pack. It's the trifecta of change. Secure yours today and get free shipping for a limited time at InfoWarsLife.com or 888-253-3139.
You are watching the InfoWars Nightly News, which airs 7 p.m. Central at InfoWarsNews.com. And your support is helping us defend liberty worldwide.